there was a bill which was brought to Parliament on UPDF. The UPDF bill is going act now, which because it has been assented, is going to help us people in Teso. With these people who come with the guns when they are not supposed to be having guns. It is also because we have so many veterans in the area. It is going to help the veterans in terms of their welfare, in terms of medical.
Honorable Michael Kabaziguruka, I'm happy to have you today.
Well, the pleasure is mine.
Yes. In January 31st, if I recall very well, yes, the Supreme Court ruled in the favor of disqualifying the court-martial from trying civilians, and that was the case that you petitioned the court. Now, up to date, as I speak to you, there has been numerous events, especially that a new twist that the UPDF bill was again passed, having the same elements that you contested. I want to really understand your position, and the other thing, who is misinterpreting the ruling? Let's start from there.
Well, thank you so much for that question. As you rightly said, that on the 31st of January this year, the Supreme Court ruled in a matter that was an appeal, as a constitutional appeal. I filed a constitutional petition back in 2016 challenging the trial of civilians in the court-martial, challenging the establishment of the GCM as a court of judicature, but also asking the court to interrogate whether an accused person can get a fair hearing in the GCM in accordance with Article 28 of our Constitution. So, in the Constitutional Court, I won the petition. Government, through the Attorney General, appealed the ruling, the judgment of the Constitutional Court. And fortunately for me, the Supreme Court also agreed with the Constitutional Court to the effect that a trial of civilians before the GCM is unconstitutional, that the composition and structure of the GCM could not afford an accused person, either a civilian or even a serving officer, a fair trial, but also that the GCM itself is not a constitutional court. Unfortunately, as we speak today, Parliament has already passed amendments to the UPDF Act, reintroducing the same structure that the Supreme Court found unconstitutional. So, as it was then, Parliament is still misinterpreting and misunderstanding the judgment of the Supreme Court. For example, in that judgment, it was clearly stated that trying civilians in the GCM is unconstitutional. Now, first and foremost, you cannot amend a constitution by simply amending an act. So, by amending the UPDF Act and in reintroducing trial of civilians would not change the fact that it is still unconstitutional.
So it was a consequential amendment?
Yes. Secondly, the Constitution itself, under Article 129D in particular, says that Parliament may establish a subordinate court. By saying that Parliament may establish a subordinate court, the same article clearly states that we have the Supreme Court, the Court of Appeal, and High Court. So anything that may be established would definitely be subordinate to those courts of judicature. Now, to say that the GCM can try offenses like murder, aggravated robbery, and all such cases, would be to give it original jurisdiction over matters which the High Court ordinarily has jurisdiction. So to give it the same would be to equate it at the level of a High Court. Besides, in the same amendments, they propose that appeals from the GCM straight away go to the Court of Appeal. Now, ordinarily, what Parliament has done is to establish another court that is at the level of a High Court, something which is still unconstitutional. The only thing that Parliament could do is to establish a division of the High Court, not to establish a new court with the same powers as the High Court. If, in any case, Parliament feels that the legally established court structure may not able to handle these crimes, then the right thing to do would be to form a High Court division, a division of the High Court that is specifically charged with the responsibility of handling such cases, instead of going ahead to flout the same constitution. We are just moving in circles. Okay? Now, looking at the constitution under Article 210, Article 210 clearly says that Parliament